So, Simon, what's the difference about our approach with fitness to practice, or with their cases rather? What's different about how we deal with the cases?
Well, I think the difference between us and perhaps other organisations that assist registrants with fitness to practice is that we take a holistic approach rather than concentrating on the basic allegations, taking them through the process and achieving an outcome. We work on the whole person. So working on the basis this is a very stressful, difficult set of proceedings, we take care to signpost mental health issues, benefits issues, we give them support workers. And then we bring a field of knowledge which includes legal and nursing backgrounds and people with all sorts of experience so that they get a much more rounded approach to their case. And we don't close the doors because they don't comply, they don't have the right subs or whatever. We will always find a way.
Why do you think they struggle with some of the representation that they get from unions? Why do you think they don't always understand what's going on with the union?
Unions are led by KPIs. They will have only a specific allotted set of times that they can give to certain cases. They're busy. They will be responsible for budgetary considerations, whereas to a certain extent we don't have that. So that makes it easier. It's not that the unions or the solicitor or the legal advisors are wrong. It's just that we can not always be looking at the clock, whereas unions are businesses and they have caseloads, and those caseloads can only be managed with a certain amount of time, and that's not a criticism, it's just a straightforward fact. So that's why.
Do you think nurses and midwives understand that when they join a union? I think they think that they'll get everything, the minute that something goes wrong, and actually they don't understand that there's limited resources, really.
Yeah, no, I don't think they do. I think because it's limited resources, there's only a certain amount of time that each advisor can spend with a registrant, a complainant, somebody with problems, and so that necessarily limits the amount of resource that can be provided to them, whereas to a certain extent we don't run by those rules.
Yeah. And why do you think nurses and midwives are generally really ill-equipped to deal with fitness practice referral? Why do you think they're not ready for it as part of their normal part of their career,
I think it's because of the nature of the beast. Fitness to practice proceedings are counterintuitive to the way that nurses and healthcare professionals think. They all work together as a team with common goals, aims, and objectives, whereas as soon as they become part of the fitness to practice investigation, it's a two-sided adversarial process. And that becomes very difficult for a nurse or a healthcare professional who's used to simply going one way with one bunch of people. And that's difficult. It's the forensic legal approach that strikes them as being difficult to work out.
Do you think it's realistic to expect a nurse and midwife to actually ever understand it, or do you think they can navigate it on their own?
I think it's very difficult for healthcare professionals to navigate something like that on their own because they're not used to the legal process. A person with a legal mind takes the facts, takes the rules, apply the facts to the rules, and comes to an outcome. Registrant is surrounded by people who have that mindset. So the NMC, the case presenters, the panel have that approach. A healthcare professional, a registrant, doesn't.
Yeah.
So
questions. So if a nurse or midwife is facing an employment investigation, a lot of them think, oh, I'm going to just resign and get out of here. Why is that a bad idea?
It's always a bad idea to resign, because if you resign, it means that the employer can still carry on an investigation and find an outcome. It also means that the NMC can still be contacted, and it also means that where you are in an investigation is there is all the evidence. And so you are going to go to potential NMC fitness to practice procedures, then the important thing is to collect the evidence, and the evidence is there live. So it's always the wrong thing to leave. You should always stay, face the consequences, investigate the issues, right or wrong, good or bad.
Yeah.
At least we've got the evidence.
So what practical things can they do? Obviously, if they're going through an employment investigation, are there things that they can do? Is there information they can collect whilst they're waiting for things to proceed? What can they do to help themselves?
First thing they can do is take a deep breath.
Yeah.
Get a pen and paper. Write down everything they can recall: dates, times, evidence, people. If there's any way to collect evidence that's not confidential, that can be done. Pictures, etc., of things, and then keep a journal, keep a record, keep a log. Always take advice before responding to questions from HR, lawyers, legal advisors, and carry on collecting that detailed log for as long as you can.
Yeah, because I think we've had a few people recently that are going through the first stages of employment investigation, and they get very urgent, don't they? They feel they've got to respond straight away and give lots of information, and that's not necessarily always a good thing at the beginning, is it?
Can be the worst thing that happens. What you've got to do is sit down, collect your thoughts together, take some advice, think about it logically, and then prepare a response.
You always talk to me about just slowing things down, don't you? Just trying to not to be what's the word? To try and get in the way of the process, but just to try and slow the speed down a little bit.
Yeah, it will take as long as it takes, and it will take the consequences that it takes. So first you need to collect the information. You need to know what's been alleged, what evidence they've got for it, and then you've got to know the procedure. You've got to find the disciplinary or process that's been applied in that particular circumstance, and you've got to read it and understand it.
Yeah.
And act in accordance with it.
And that journaling and getting timelines in place and things, definitely.
Keep records, journal it, never admit anything, take advice.
Yeah. So one question we're getting asked at a lot is what's the screening stage of fitness to practice? What is that about? Why? What does it mean? What do the NMC look at in screening?
Okay, well, the process is shrouded in a certain amount of mystery. Screening is looked at by people who screen. They will look at the basic facts of the case and determine whether there is a viable fitness to practice set of issues. And that's not a very high bar. It's reasonably high, but it's not a very high bar to pass. So as long as there's some evidence, some indication of problems and issues that need to be addressed, some issues of fitness to practice, then they will collect it doggedly, collect evidence, take statements, collect documentation, and then arrive at a conclusion on the balance of probabilities, whether there is sufficient evidence to take the matter forward or whether it should be left there.
And you've already mentioned that. I'm just squeezing this extra question in as you said it. So balance of probability. So that is the civil standard that NMC process is based on. Now, a lot of people get confused because they always think of the criminal system. Can you just kind of explain very quickly, if you can, what the main difference is between the way the NMC assess things, balance probabilities, and the way, say, the police would investigate things from a criminal standard.
Well, criminal standard is beyond all reasonable doubt, so that's 99%.
Yeah.
100% sure. Whereas balance of probabilities is more likely than not, so that's a 51% threshold. So it's a lot lower threshold for the civil standard. Is it more likely than not that it happened? Is there a 51% chance of the matter arriving at a conclusion that fitness to practice has been affected by these incidents? Remembering, of course, that this is not a strictly adversarial system. It's supposed to be a no-blame situation with a culture of openness. However, this does tend to become a little bit overshadowed by the requirements to find some form of issues at fault, and that tends to move towards adversarial, and that's the problem you've got to worry about as a registrant, because you're responsible for everything that happens.
Very subjective, though, isn't it? Balance of probabilities, because what one person may think is probable, another person may think is not as probable. So it's how on earth do they get to that decision?
Well, more likely than not is are there witnesses that are saying similar things? Is the documentation that proves issues and errors or problems? Is there anything that shows a defect of practice, or is there anything that indicates that the code of conduct has been breached? And that's just in general terms, so it is reasonably easy to show that with the right amount of evidence. Taking into account, and I'm not sure of the figures, taking into account the fact that the NMC will tell you the vast majority of cases are dropped at the investigation stage.
Yeah.